Good afternoon, America, and you are now tuned in to Fair Housing is the Law. I am Michael Smith, and this...
I'm MJ Borelli, and we're both with the Fair Housing Council of Central California. Even though we're in Central California, we hear housing rights issues all the way up Central California to the Oregon border and the Eastern Sierra. So, what we do is we work really hard through a program of investigation and enforcement to help people through episodes of housing discrimination issues. One of the things we wanted to talk about today, Mike and I, is, the Fair Housing Act, which is what we enforce exclusively. And where that comes from and really what it is. We get complaints from people for all kinds of things in our offices. Everything from slumlords to I'm getting evicted. We're not legal aid. We do something a little bit different than that. What we do is we investigate claims of housing discrimination as they're set forth in a very, very important law called the Fair Housing Act. Now, this is a federal civil rights law that deals with housing discrimination and corollary housing issues like mortgage lending, home product insurance, and sales. So we're looking at those housing guys that could be a landlord, could be a real estate agent, could be a property company or a real estate company that discriminates against individuals. Mike?
Yes, we call it predatory.
Well, it's not exactly predatory, even though the outcome looks as though it could be predatory. Lots of people talk about predatory practices by banks or landlords. More commonly, you hear about predatory practices with banks and other financial institutions. But I've never seen a law in the books yet that makes it illegal to be predatory. So what we're talking about are strict prohibitions against housing discrimination. And really, all of these kinds of activities, which we're going to talk about, have to do with, is your discrimination because of either race, color, national origin, religion, gender, disability, or family status? And we're going to try to, in this short half hour, try to cover all 7 of these areas. And in this law, which has been around since 1968, so it's always a mystery to me why nobody knows this law is out there, because it is. And because of all of these, what we call protected areas, race, color, etc., the kinds of behaviors that are illegal would be things like refusal to rent, lying about availability, steering meaning, you may not like this property, you should go to this other property.
That happens a lot.
And that happens a lot. That's quite a common practice. Discriminatory advertising, and a lot of times, we're kind of seeing a turnaround in that we're seeing, I used to see ads for subdivisions that were actively selling lots to build a new house, where often in the advertisement, the potential buyers were almost across the board 100% white couples. And, we're beginning to see a change in that, and it is a violation of the Fair Housing Act to do discriminatory advertising. And we can talk about that as we go along as well.
I have a question. Steering. Some people might have that happen to them and don't see nothing wrong with it. So why would they steer you somewhere else? What would be the reason for them doing that?
Well, keep in mind, all of these behaviors have to be linked to either race, color, national origin, religion, gender, disability, or familial status. So some good examples of steering would be We don't want you to live here because of your race, basically. We want you to live over here where we have others of your race living. And I know our agency was involved in an action against a property company that had an apartment complex in Fresno, California. And, well, I believe this was the Courtyard Apartments. There's probably still around. And there was the Courtyards 1 and the Courtyards 2. And the Courtyards 1 had availability, and they were advertising availability. In other words, they had units available. And when we had black investigators who were posing as home seekers who went to inquire about availability, they were steered to a sister complex next door that had the same name, but it was called Number 2. And Number 2, all the people of color lived in Number 2. All the people who were white lived in Number 1. And so an action was taken against them by us and the federal government because that was steering. You're not supposed to segregate or isolate folks. I remember not so very long ago seeing lots of apartment complexes here and other places where steering was because you had families with children, which is an area called familial status in the Fair Housing Act. So what you would have is you would have the apartment maybe split in two, so to speak, where, for example, not always, sometimes this was configured differently, but a lot of times the families with children might be in the back of the complex, and the people who didn't have minor children were in the front of the complex. And so what the landlords or property agents would do is call one side adults only and the other side a family side. So those are two pretty common examples of steering. But certainly you could be steered because of any of these other other reasons too. But most common kinds of steering that I've seen over the years have to do with adults only, which you can't have anymore since 1988. You can't have an adults only complex. Neither can you have an adults only and families with children side of an apartment complex.
Adults only, so that's telling you no children allowed.
Pretty much. A few years ago, there was a lot of development in the Los Banos area, new subdivisions, etc. This would have been, mid-2000s. And there actually was this huge billboard on the main highway, which was Highway 152, going west. Los Banos was becoming a bedroom community for the Silicon Valley, where housing was becoming, really, really tight as people were moving there to work in the tech industry. So a lot of folks bought houses or rented apartments in places like Los Banos and would commute to San Jose and Santa Clara Valley, Silicon Valley from there. And there was this giant billboard right on the highway, adults only living. And this was, as I say, around 2005. And, it's blatantly illegal. You would think a developer of housing would know this. And more so, the city of Los Banos or the county of Merced, where it's located. So we contacted them as the Fair Housing Council. We contacted the developers and agents that were selling these lots. That, you're going to have to take that billboard down or we're going to sue you, basically. And they had the billboard down within 24 hours. They understood what their mistake was when we began to tell them that you can't have adults only living. You can have senior living, which is allowable under another federal law called the Housing for Older Persons Act, sometimes referred to as HOPA. And that involves a complex or a housing development. It could be condominiums, it could even be a subdivision where there's going to be age restrictions for two groups of seniors. One type would be you have to be, or at least one person in your household has to be at least 55 years of age, and 80% of the total tenant population, or if you're buying it, whatever you're called at that point, homeowner, 80% of the residents have to be at least 55 or older. And then the other type of senior housing would be you have to be at least 62 to live here. Those can be mobile home parks, condominium developments, seniors, subdivisions with homes, apartment complexes. And if your age limit is 62, then 100% of your resident population has to be at least 62 or older. So that's where and you can't see adults only. I've also run into this in the foothills. There's various in-century developments all up the Eastern Sierra, mobile home parks, communities. I saw one community that had manufactured housing, which is, kind of like a mobile home park, but not, where they were advertising adult living. And, I went to that housing development and said, you can't do that. You can talk about seniors and whatever the age restriction model is for your community. And by the way, if you're making, as a developer or the property agent for such a community, you have to stay that way, or you lose the one and only exemption for familial status violation in a way. So adults only can be senior, but you can't say adults only. And then you've only got two ways to go with the senior developments in terms of age limits. And you can't call it adults only.
What about the one that's used a lot? Too many kids.
Well, too many kids is the same thing as saying no kids are allowed. Sometimes you will have these. This is a way that a property agent might discourage families with children from living in a rental community, or even certain types of subdivisions. And they come up with these, what we call discriminatory occupancy requirements. And they will come up with stuff like, fire marshal thing, and you can't have more than so many folks. There was a fairly famous case out of West Chicago a few years back, wherein you had a lot of Mexican migrants that were populating this particular area of Chicago. West Chicago is its own, city. And so in these neighborhoods in West Chicago, where you had a lot of these Latino families, mostly Mexican-American, moving in with their extended families, which might include their, relatives like a father-in-law or mother-in-law, grandmother, grandfather, and their children. And so they would have, the city would dispatch code enforcement folks to go out to these homeowners. These were people that owned their home or were buying their homes in West Chicago, and tell them there were too many occupants in their household. And they would come in. I mean, these guys weren't even operating during normal business hours. There were witness statements about coming in at midnight and telling folks that they had too many occupants in the building. And what happened was a lot of these folks sold their homes and sold them at a loss. So there were all kinds of harms because of this kind of discrimination, and this is basically familial status discrimination disguised as some sort of official occupancy requirement. Another example that I can think of was a couple that came to our agency. They had rented a one-bedroom apartment. They were both professionals, saving their money up to buy a house, or, to at least come up with a down payment. And they were in a one-bedroom apartment, and as time went by, as they're living there, the wife became pregnant. And when she became visibly pregnant, the manager came to her and said, you all are going to have to leave. And, in this day and age, this is in the 2000s. And they said, well, how come? Well, we only allow 2 people in a one-bedroom apartment. And that's balderdash. They'll come up with all kinds of supposed codes or whatever, but those codes do not trump the Fair Housing Act. This was clearly a case of familial status discrimination. This unborn child was not going to be welcome in this one-bedroom apartment. So that would be another form of unfair occupancy requirements.
Is it can they say I don't know if you covered this or not, but can they say like it's not enough bedrooms?
Oh, that's just what they usually come up with. And, there's no rule that says a person has to sleep in an actual bedroom. They could be sleeping in the living room. They could be like the 5 little peppers in the kitchen.
They could be sleeping on bunk beds.
Exactly. So, once again, a lot of times these are unfair occupancy requirements. I used to run into other kinds of standards. For example, this was a family that had foster children. They were foster parents, and they had a couple of these foster kids, and they had a 2-bedroom apartment. And the 2 foster kids, one was a gal and one was a boy. And the county came in and said, no, you have to have separate bedrooms for them. Once again, that was a violation of the Fair Housing Act to make that requirement. So, yeah, all kinds of things have been
That's good to know.
hiding as something else, and in reality, that's what's going on. So, familial status is kind of making a comeback, and I don't know if this is because of, the pandemic, when maybe people were moving in with each other, and, the landlord starts pressing on them that, you can't have more than 4 people in this 2-bedroom apartment, which is complete balderdash. It's just not the case. But one of the things that I want people to remember in terms of the Fair Housing Act, that the Fair Housing Act was a culmination of a civil rights era in our country that had been going on for some decades. It wasn't the end of a fight for civil rights, but this was, you have to keep in mind that the whole movement was predicated on this reality of black folk, African Americans, were being treated differently than white folk, and public access was limited for them. And of course, with the Fair Housing Act, housing was opened up in terms of a person's choice, regardless of their race, color, etc. And I think we have to remember that the whole civil rights movement was based on this black-white problem, where folks were not treated equally because of their race and color. And even today, sometimes race is the motivation behind other kinds of, no, you can't move into this place, refusals to rent, for example. I think we talked about this on a previous broadcast, but one of the things that we've discovered is a lot of folks are being told, you have a Section 8 voucher, we're not going to rent to you because you have a Section 8 voucher. And the holder of that voucher, just happens to be, by coincidence, I don't know, happens to be African American or a person of color. So sometimes one form of discrimination is masquerading as another. Would that be one way to put it?
Yes.
Because that refusal to rent is not only about a state violation here in California, i.e., we're not going to rent to you because you have a Section 8 voucher, when indeed state law says you must rent to those folks who have a Section 8 voucher. And because of the person's race. And when we go in and investigate some of these instances that we hear about from complainants, it's just interesting that the folks that are refused because of their Section 8 vouchers are generally people of color or a different race. So, a person who comes from a different country, and we're not talking about citizenship here, national origin, we call that. And generally speaking, not always, but in our neck of the woods, we're talking about Latino persons, or Latino homesinkers, renters, etc., that are generally going to be from Mexico or Central America. There are other parts of the country where you might be discriminated against because you come from Poland, or because you're Middle Eastern, or you're a Syrian refugee. That is discrimination on the basis of where you came from, your national origin. And I've even had and proved claims by folks who were white but came from a different country. They didn't come from the United States. In one case, I had a lady that was from Australia whose job had sent her here, and she had trouble getting a rental because she was from Australia. And that's kind of interesting. Sometimes people with accents are going to be treated differently, and they may be white folks, and they might be treated differently than white folks who have no accent. So these all can be forms of national origin. Now in California, we take the law even further, your ancestry. So this can mean a whole lot of different things, including those people who are Native American, here before you. And they get discriminated against, especially in some of the states that are in the Great Plains, in terms of housing. They're competing for housing with everybody else, and they suffer a lot of housing discrimination in places like Arizona, Wyoming, Colorado, Montana, because of their being Native American. And they're not necessarily a different race. I foresee the day when race is going to become one of those terms that may not be used anymore. 9 times out of 10, it's about a person's skin color or facial characteristics.
Or it could be status too, poor, rich.
Well, yes, and probably state law covers those folks for some arbitrary reason. And the state laws, which are substantially equivalent to the federal laws, have even more detail attached to them here in California. So a landlord, for some arbitrary reason, can decide that he doesn't want a whole class of people. I don't vote to, or I don't rent to Republicans, or I don't vote, it's those primary elections, got it on the brain. That's all you're hearing about. But arbitrary reasons generally involve a class of folks, people with tattoos, people who ride motorcycles, students, members of the military. That all can encompass what we call arbitrary class discrimination. And there's certain parts of California where, you're going to see a lot more of this than maybe in Fresno. I do see it in our neck of the woods. But anywhere that there is a military base, interestingly, you're going to see a lot of arbitrary class discrimination based upon a member of the renter's family that's in the military. And a lot of times there's kind of familial status rolled in with that. And, this is against the law. As a landlord or property agent, you can't do that. And the excuse for members of the military, well, they may be deployed somewhere, so we can't count on them not to break a lease. So whatever you're coming up with, it's wrong. It's illegal. You can't do that. Probably the largest amount of complaints that we see have to do with disability, and it's been that way for years. Disabled people not so very long ago were seemingly invisible and locked away up until you had laws like the Fair Housing Act and the Americans with Disability Act. Americans with Disability Act is about public access, of course, and that's why you're seeing curb cuts on sidewalks and that kind of thing. And being disabled doesn't mean that everybody who's disabled is in a wheelchair. And I think a lot of the general public, including the landlord population out there, believes that all disabilities are, visible and apparent. And that's not always the case. Or if you're blind, people recognize blindness and they recognize folks in a wheelchair as, or hearing impaired. Even hearing impaired are not taken seriously as a disability by many property agents, which is kind of a mind blower, but that's how it goes.
What about the pets, where you have I know a lot of military, they get them a little dog
As an assistance pet, because they're
for the I can't think of the name, but to keep them calm, they use a
yeah,
pet
that's still, it's like a service animal.
Yes.
And sometimes people call them emotional support animals.
Yes, that's what I'm
which
trying
really, it's about disability. And if you're disabled and you've been prescribed an animal, whether it's a goldfish, a cat, a dog, it's whatever it's doing to enhance the well-being of the owner, they have to be allowed in any kind of housing situation. And we've talked about this before, and probably will talk about it in the future. Landlords have to make reasonable accommodations in the terms, rules, and conditions of tenancy for disabled people to allow them equal opportunity to use and enjoy a dwelling. Which means if you have a no pets policy, that's out the window when you have a disabled person that has some kind of a support or service animal. Under the Fair Housing Act, we call them service animals. And in order to be a service animal, they only need to do whatever they're individually trained to do to enhance the well-being of the owners. I want to thank you for tuning in to Fair Housing, It's the Law, and we'll be talking to you soon. Thanks so much.
It was good, MJ.
Oh, was it?
Yeah.